Video footage of Fulton County Judge Scott McAfee. In the first televised hearing, Kenneth Chesebro's motion to separate his case from Sidney Powell was denied by the court, and they will go to trial together on October 23. The judge hasn't made any decisions yet on whether other defendants will be tried at that time. Happen Just Now enjoy hearing your thoughts. Please leave comments. Thanks.
Your Honor, just briefly, just for the purpose of the record, I want to make clear that there is a dispute about severing the 2 from the 17. I think the state's made that clear, so I just want to make sure that that's cleared up for the record. There's some state, and just before we depart, we would just ask for, if there is briefing, what that briefing schedule is.
Of course. No, I think we still have plenty to talk about before we wrap up for today. So, obviously, I think as has been made clear, we're on an expedited timeline with these statutory speedy trial demands, and we are certainly here ready and willing to provide both defendants that right, and we plan to make that October 23rd trial date stick. With that in mind, I don't know if we're always going to be able to have the luxury of pre-hearing briefing and post-hearing briefing, and some of these issues may require a little more exploration than others. This one, I don't think is one of those. When it comes to the question of whether to sever Ms. Powell and Mr. Chesebro, I certainly agree that there are always guardrails, and that RICO, as indicted, can't just be used to do anything, but it is broadly construed, and those guardrails are found in those 3 factors. And the 3 factors traditionally that we've gone through really don't seem to be at play here. We don't, for one, the antagonistic defense issue is conceded. Both parties are going to be claiming they have no idea who the other is and won't be pointing the fingers at each other. I think the argument that they're charged in 2 separate kind of silos of charges strengthens the idea that there won't be confusion amongst the jurors and there won't be spillover evidence. So really the strongest thing that I'm hearing, and I don't think it's invalid, is that it's going to be kind of a matter of inconvenience and potential added expense to have both defendants sit together. And that's certainly true, but there's also other judicial economy aspects to consider, and issues of inconvenience as well. We talk about the jurors. I don't think we can take for granted that these would both be 2 equally 4-month-long trials. I think it could easily be twice that with multiple defendants, and I think we need to take into account the fact that one docket goes entirely on hold while this case is going. And instead of it being, if we're purely considering aspects of judicial economy, which to me was really the only valid argument here, I think taking up 2 dockets and for a period of 4 months also weighs into that, as well as the voir dire process and the inconvenience to the jurors. So based on what's been presented today, I'm not finding that severance from Mr. Chesebro or Powell is necessary to achieve a fair determination of the guilt or innocence for either defendant in this case. And so I'll deny Mr. Chesebro's motions to sever from Ms. Powell. I'll deny in part Ms. Powell's motion to sever from Mr. Chesebro. And the plan will be to enter a scheduling order for Ms. Powell mirroring that of Mr. Chesebro, with the October 23rd date holding. It sounds like the state is still sticking to the position that all these defendants should remain, and they want to address some of these removal issues. I'm willing to hear that. I remain very skeptical, but we can. I'm willing to hear what you have to say on it. And so, but again, because we're on a limited time frame, I don't think we have the luxury of waiting. So, how long do you think the state needs to respond to that issue?
2 weeks, Judge?
I don't think we can do that. There's going to be motions deadlines for the other defendants, and we need to get scheduling orders entered.
I had to ask.
That's fine. And I had to deny.
Understood. 10 days?
Well, I think the 10-day mark from today. I know, again, I'm sending the indicator that folks are going to have more than 10 days to file their standard post-arraignment motions. Let's see if we can have that by Tuesday of next week. again, this is limited to how you think logistically we could possibly keep these defendants together, and I think we can limit that to 10 pages. And if anyone else wants to respond, they can to that issue. But Mr. Grubman.
Yes, Your Honor. This is, if you're still going on this issue, I did have a quick other issue just since we have your attention to bring up. We do have a pending motion to talk to the grand jurors.
Right. Let me get to that. So, again, knowing that Mr. Chesebro and Ms. Powell are hurtling forward and the motions are going to keep coming in, I don't think it makes sense to just have these all pile up. So we would pretty much maybe just keep having these weekly sessions together and handle them one at a time. So to that end, I believe we're starting another trial next week. I think it's a murder trial we're doing next week, but looking at Thursday or Friday of next week, how's everyone's availability? I only saw motions from Mr. Chesebro, so I guess the question's only directed towards Mr. Grubman and Mr. Aurora. I'm looking at Thursday or Friday morning.
We're here whenever the court instructs us to be.
Got it.
Your Honor, could we ask for Friday morning? I've got to do a sentencing
On Thursday morning?
afternoon.
Thursday afternoon?
You know, Florida's saying hour is going to be 3, so I just figured we could have, depending on the motion, just
Well, so far you've got, I believe it's the 2 related to the grand jury, and then you have 1 more related to the supremacy clause.
we've got 2 more coming either today or tomorrow.
Maybe we limit it, since the grand jury issue is something that might take more time to flesh out if it's granted. Maybe we limit it to those 2 for next week, and we can save the constitutional arguments for another day. Can we still do that Thursday morning, though? Assuming if it's just those 2 related to the grand jury.
We start at 9.
That's the plan.
Okay,
Yeah.
Thursday morning, 9.
I'm sorry, John. For the record.
Sure.
Thursday morning or Friday morning?
Thursday morning, it sounds like everyone, and we'll do those 2 grand jury motions. And then, Mr. Rafferty, if you want to jump on board and adopt them, we can obviously work you in.
Yes, Moran. Just quick clarification. The briefing from the state by Tuesday, is that going to be on the question of whether it's going to be a trial of 19 or a trial of 2?
That's right.
Thank you.
Nothing else from Mr. Chesebro, just time, Your Honor.
Okay, thank you, Mr. Grubman. Anything else we should address since we're all here together?
Real quickly,
Sir, yes, sir.
some of the lawyers for some of those other defendants are in the courtroom, may well have an interest in the issues and the arguments that the government makes about whether it's a trial of 19 versus a trial of 2. So are those other lawyers permitted to submit some kind of briefing in response to whatever the government says?
I think that would be fine. I think some already have. I think folks have already been submitting severance motions saying that they're not ready, that there are conflicts, and so that might very well suffice. But certainly, I'm not going to foreclose that opportunity if they want to be heard in more detail. So we'll send out an email to everyone indicating as much.
And relatedly then, on Thursday morning, will we potentially have some discussion of that motion as well, that briefing?
We can. Again, I think by then I'm hoping to have already ruled and issued some scheduling orders because we need to get that clarity so we can focus on what lies ahead. Anything else? Okay. Anything from the state? All right. Thank you all. See you next week.
Thanks for watching. Subscribe to Happen Just Now for more content about accountability of all public officials and policy and procedures.